Okay, cool. So, hi everyone, welcome to the first panel of Law School Basics on How to Study. This year we are kindly sponsored by Allen and Overy, so I wanted to thank them for supporting us and getting this panel series to you in 2021. My name is Sinem. I am the Vice President of the Sydney University Law Society and I head the education portfolio. This panel will focus on study techniques, but the later panels will be about assignments and then exams. So we have three panelists today, two students, Anuki and Jasmine, who are actually sitting beside me, and a professor, Professor Jason Harris from the law school. Would I be able to get these panelists to introduce themselves? Maybe Jason, we can start with you.
Yeah, sure. Hi, Sinem. Thanks very much for inviting me to speak at this, which I'm happy to do so. I'm Professor of Corporate Law here at the Law School. I've been an academic for the last 20 years, worked at a number of universities. I've been here at Sydney for the last 2.5 years. I teach corporate law in semester 2. I also teach insolvency and contracts in semester 1. And I think the reason that Sinem asked me to come along is because in my corporate law class, I do a series of webinars, optional webinars for students that are looking at how to prepare for the mid-semester exam, how to prepare for the final exam. And so she's asked me along today to speak about some of those tips, which I'm looking forward to getting into.
Awesome. Jasmine?
Yeah. Hi, I'm in 4th year law and I also studied chemistry as part of my other degree. I've been involved in SULS, doing a bit of mooting, and for 2 years I've been working with a barrister. So hopefully I'll be able to provide some student insight as well today.
Perfect. Anuki?
Hi everyone, I'm Anuki. I'm in my 5th year now and my first degree was an arts degree, majoring in government and international relations. At uni I've done a bit of mooting and I also work at a commercial law firm. That's pretty much me.
Awesome. Okay, so we'll get started on the questions. It will be very conversational, but I will address some of the questions to specific panelists, and then whoever of the panelists feels like they have something else to say or add to it, you can just jump in after that. The first question I'll just ask first to Anuki. What are some sturdy and reliable study methods to equip students for a productive semester?
I think my two favourites would be really focusing on lecture content first as the basis for the rest of my study, and the second would be forming a study group to take me through the semester in a really supportive environment. In terms of lecture material, I think, of course, your tutors and unit coordinators will write the exam and know exactly what they want assessed, and so if you take your direction from them, it's really easy to get a sense of what the course is about and what the objectives of it are. And then you can kind of frame your reading and other studying around that content. And in terms of a study group, firstly, it's much easier to see and test what you actually do know and get perspectives from other students because you never really cover all the bases yourself. And it's also much, much nicer to be in a group setting and have the support of people around you while you're studying.
Yeah, and on that note, we have peer-to-peer study groups, which you can find on suls.org.au, where you can link up with other people, where SULS will match you with people who are also interested in the subjects that you want to do. Does anyone of the other panelists have anything to say? But we will have other opportunities to talk about study methods as well. But any other comments? Yeah.
Yeah, I mean, just on forming study groups,
Jason,
I think it's so
you're unmuted, but I can't hear you. Can you guys hear him? Oh, okay. Well, don't worry about me then.
I thought, it says I'm not muted. Yeah, I think forming study groups is really important. I mean, from my perspective as an academic, what you're doing in, say, tutorial questions, what you're doing in assignments, what you're doing in exams, is you're typically trying to formulate an argument which is persuasive. You're saying, you know, here's a problem, here's an issue, this is what I think should happen here. And so if you do that in a study group, you're able to test yourself, like what the marker is going to do, what a judge is going to do, what the partner is going to do if you're working in a firm, is test you. And if you say, you know, this is the rule and here's how it should work, and this is why it should work this way, you're going to get tested on that. People are going to contest you. It's all about competing arguments. So the more practice you can get in developing persuasive arguments by persuading your group members, I just think you end up giving much better answers. Like, what you want in terms of your assessment is the marking going, yep, okay, good point, yep, oh, what about, oh, yep. So test that out with your friends, test it out in study groups, mark each other's papers and really try and pick holes in their arguments. Well, you're saying this, but what about this? You've missed this point in this case. What about, what about this decision? The more practice you do and the earlier you start doing that in law school, you'll have much more comprehensive answers.
Yeah, definitely. I only really started properly working with another person and studying with another person last semester, and that actually improved my marks a lot. And I even had we had a Google document, and we used to do comments make comments on the Google document, and we could both see it as we typed and going through the problem questions. So yeah, definitely study groups are very important. The next question is directed at Jasmine. What should we do, or what should I do when I'm overwhelmed with content and I'm already falling behind on tutorials and lectures? What's the best point of action?
Yeah, so I think the first thing I'd say is just be kind to yourself and don't try and beat yourself up for getting into that situation, because you could very easily fall into just a negative spiral. But once you've sort of hopefully just taken a moment for yourself, I'm open, I don't know what other people think about this, but personally, if I feel like I'm falling behind on a tutorial and lecture, I would just say always show up to the tutorial no matter what, even if you just only get a look at a glimpse of the tutorial. I've had friends in the past who said, oh, I'm not going to come this week because I didn't do the reading and I don't feel prepared. I think that's not a great attitude to have towards it. But then also in my experience, I think if you have, say, fallen behind on week 4, I would just try and move on to week 5 and stay on top of what's actually happening in class, so you don't just fall down a spiral of constantly being behind, and then slowly start to edge away and go back to topic 4, for instance, and go through the lectures and the tutorial again and eat away at that bit by bit, rather than just spending time in week 5 trying to do week 4 and just in that way never really being on top of anything. But I know other people have different sort of opinions on that, so I'm interested to see what the other panelists have to say.
Yeah, does Anuki, Jason, do you have anything to say about that?
I do, but Anuki, do you want to go first?
I think I'd agree with Jasmine. I think I've tried both approaches in the past, and the one that works for me is keep still going on with the content that the class is covering, because you do dig yourself into a deeper hole, and when things add up, it's easier to feel defeated when you're looking at week 3 content. Everyone else is on week 6. It's much easier to just keep going with the class and making sure that you're understanding the content that's being covered right then and there.
So my only addition to that would be, generally I'd agree with that. It does depend on the subject, and it depends on the topic that you've fallen behind. So some subjects in law school, there's a range of different issues that they're going to be looking at. This week it's going to be this, and next week it's going to be that, and whatever. And it doesn't necessarily build. But with some topics, it does build. And, my area of corporate law being an example, for those who've already studied corporate law, the central foundational topic we do in class 3, and that's what is a company and separate legal entity and really what that means. And I'd say in my subject, if that's the week that you don't get, none of the rest of the course is going to make sense. So my advice to you would be is, if you really feel like you're lost and you're overwhelmed and you're just not sure what to do, I'd say have a chat to the lecturer, have a chat to the tutor, and just be open and honest. We don't think people are superhuman. Neither do we think that people spend 60 hours a week doing nothing but studying for law school. Everyone has lives, everyone has other commitments. So just be open and honest and say, look, stuff's happening, I've just fallen behind in this week. Would you suggest that I just keep going at this current pace, or would you suggest that I go back and do that? Because if it's a foundational concept, you might actually get more confused as you go through the semester. I see it when I'm marking final exams. Students still don't know what a company is. And I think, what have you been doing for the last 10 weeks? Had you told me 10 weeks ago, I could have helped you. I can't help you the night before the exam.
Definitely. I actually have a few questions for Jason. What is the actual value of doing all the readings?
So good question. And again, it kind of depends on the subject. So some subject coordinators will just give you things that they think are really essential. And they'll often give you like quite specific reading assignments, like these paragraphs, these pages or whatever. Other people take the approach, read for the next class, read 3 chapters of the textbook and these 12 cases. And I mean, look, it'd be great if you could do that. I'm not sure that I think anyone does all of that reading. So in terms of what's the value of doing all the readings, I think it depends on the reading. And by that, I don't mean, is it this article or is it this case, but the different types of readings. So there's essentially 3 types of readings you're going to get in law school. One is going to be cases, one is going to be some form of textbook, and one could be things like articles, law reform commission reports, or some other matter. I'd say the cases are always the most important, because what we're doing in class is essentially working with legal principles. Where do the principles come from? Mostly from the cases, in applying the statute or applying principles of common law. So going through the cases that are set as the prescribed reading, so that you're able to say, when we're looking at a situation, well, this is a bit like this case, or this is quite different to this case. That will help you with your analysis. Now, in saying that, some of these cases are 100+ pages long. I don't expect that people are going to read all of that. But what I always tell students is, reading a case and even reading a textbook is not like reading a novel. And what I mean by that is, you don't start at the beginning, you don't finish at the end, and it's normally not that fun. So when you're going through and doing your legal readings, I suggest that you do some preliminary kind of reading analysis before you get into the detail. So have a look at the syllabus, have a look at the range of cases, open your textbook and just flick through the relevant chapters. Get a sense of, what are the keywords here? What are the headings that are being used? What's kind of the flow of the information? Have a look at the lecture slides. What are some of the headings? What are the cases mentioned? Are there little quotes? Are there little summaries? And you just build up a picture. Today's topic is about these issues, and here are the main cases. Then what I do with cases is go and read the head notes. Always read the head notes as a minimum. You should be reading the main cases if you can, but at least read the head notes, because particularly with modern head notes last 20 years in the official law reports, you'll probably get a reasonably detailed discussion of the facts. Some textbooks don't give you a very good summary of the facts. Now there's little study guides that you can get for those sort of things. You might have a set of notes that you bought on the internet. It's got a nice little summary, that's fine. But if you read the head note, it'll then give you the important bits. Here's what the court found. And normally they'll say, here are the pages, here are the paragraphs, here are the judgments that were used in that analysis. And if you've done that little bit of preliminary work, just kind of scoping out what is the extent of this topic, what are the main cases, what are the issues, what are the main sections, you'll start to see confirmation of that. Oh, that case was mentioned in the slide and it's mentioned in the held line of this head note. Then what I'd do is I'd go to the relevant paragraphs in the judgment itself, and then I'd normally read maybe 2 or 3 pages before, 2 or 3 pages after. So even if it's a 100-page judgment, it's not going to, unless it's Kirby, it's not going to be 100 pages of legal citations. There's going to be an awful lot of, here's the history of the dispute, here's the arguments of the parties, here's the relevant law, here's where it applies. It's the application bit that you really want. So if you read the head note, it'll tell you which passages to read, and then read a few pages before and a few pages after, just so you get a flow of the argument. So that's with cases. With textbooks, I mean, it depends on the textbook. Some textbooks have a lot of materials in them, so that's a bit more challenging. But most textbooks, they're just trying to explain the law to you. But again, I'd say if you do that preliminary work, have a look at the slides, have a look at the unit outline, maybe have a look at something like Halsbury's Laws of Australia, even doing some basic Google searches on the topic, just so you get a sense of, okay, this is criminal law or this is corporate law, this is where this topic fits, here's the basic outline of this topic, and then go through and do the reading from the textbook and take notes. But the biggest tip that I give people is, not everything that's written in a text is going to be essential. So there's going to be some information which is really important. That's where they're saying, this is what the law is, this is how it works. And there's going to be a lot of background. Here's the history. Here's what it was 10 years ago. Here's what I think about it. Focus when you're doing your reading of, what am I trying to get out of this? I want to know what's the relevant law and how does it work here? So that's what you're going to be looking for in the readings, rather than literally trying to summarize every page. I've seen student sets of notes for one class that's 100 pages. I think that's literally longer than the textbook. Like, you are just overworking things. And I think a lot of students get really stressed about that. I'm taking so many notes and it's not sticking. That's not the goal is not to recreate the textbook. It's to understand, here are the 4 or 5 important points and here's how I apply them. So one of the skills you get in law school is being able to digest large volumes of information relatively efficiently and to pick out, here are the important bits. Because, you know, as those who are working in firms would know, you get put on a big discovery matter. Here's 1,000 emails that I want you to go through and find the ones that are relevant. It's about processing large amounts of information, but know what you're looking for before you start reading. If you just read fresh, oh, this is a novel, I'm just going to read every page, you'll probably miss the important bits. So get a sense of the topic, know what you're looking for, and then go and do the reading.
Yeah, definitely. And I think another life hack I've discovered recently is for the overview of topics, you can even just like type it in and see what law firms have actually made articles on that area of law, because they always condense the information so that clients can read it, like everyday people, and that would really help a student as well. That's been a recent discovery of mine. But another question I have for Jason is, what is the difference between a casebook and a textbook? Is one more efficient than the other? And you might have touched on this already.
They're really doing different things. So a traditional casebook is giving you an extract of the case. So you don't have to read 100 pages. You can just read 4 or 5 pages, and it's really just giving you the core element. And in many areas, that's enough. You do need to have a good understanding of the cases in terms of the facts, because what you're taking from these cases is, this is the relevant principle of law, but that principle of law under stare decisis is only binding based on those material facts. So it's if we have fact A, B, and C, then this rule applies in this way. So what I've found with some case books is the summary of the case facts is not enough. And in some of the extracts, they'll just give you a quote and that's it. And they won't tell you anything else. And so some students, I think, fall into the trap of thinking that legal analysis is, you know, case equals rule. And that's all I need to do. And I mean, that's okay. It's better than nothing. But if you want to get a good mark, you need to be really analysing why you think the law applies here. It's not, well, just that case said this and that's relevant for my argument, so therefore I'm applying it. Tell me why that case is relevant here. So you need to be across the facts. And that's why I've suggested for all the prescribed reading cases, read the headnote, get the summary, do your own little summary. Don't just rely on summaries you bought on the internet, because what if they're wrong? So a textbook's really different, because a textbook then is really trying to explain the law to you. And it might give history, theory, a bit of context. It might highlight some issues that maybe are contentious, some issues that the textbook writer thinks are wrong. One tip that I would give you, and certainly something that helped me in law school, 26 years ago or whatever, was actually go and have a look at multiple textbooks. I'm not saying you got to read 5 textbooks every week, but even if you just skim them, have a look at the sort of cases that they cite, have a look at the headings that they use, the sort of statutory provisions that they refer to, because the primary source is what you need to be using in your analysis, the statutes and the cases. The textbooks, the articles, the legal encyclopedias, the law firm blog posts, whatever it is, that's just someone else's view on what the law is. Now, that's helpful. Hopefully they're experts who are writing the textbook, but always go back to the case. Don't just rely on what the textbook says. And when we're marking, it's so obvious when students are doing that. So if you've read the case and you've got pinpoint references and you're able to draw out with your analogies from the case, that will really stand out in your assignments.
I might just add something onto that, actually. Everything that's been said is like incredibly good advice. I feel like I'm also learning things. But in terms of the value of doing all the readings, I think if you're aware, and it's been pointed out in the lecture, that there is sort of a close majority, say like a 4-3 majority or something like that, it is sometimes important to go through the individual judges and look through the different reasoning that they took in each case, because it is more of an undecided or uncertain issue. So I think in that case, if you see a case that is in one of those cases, I would pay particular attention to that. and definitely just sort of get a feel for which judges were in the majority, minority, were they united in that view. And that can, I think, sometimes like distinguish a distinction or high distinction answer in my experience. Yeah.
Can I just add something to that? One of the things that's really useful for these types of issues is to put the case through a citator. So use something like Casebase or LawCite on OSLI. So where you've got these multiple judgments, because what I found is, you know, who's more qualified than me to talk about what this case means? It's other judges who are having to deal with these issues. So if you've got an older high court case where there's this split in judgments, for example, like you often have in constitutional law, for example, put that case into LawCite or put it into Casebase, and then have a look at subsequent cases which have either explained or applied or distinguished that. Because that then will give you, essentially, this is another judge telling you what this case means and what the authority is. So I found that very helpful.
Yeah, like these are all really good points. And another actually question for Jason. This is a bunch of questions that are like about the actual like technicalities of law school. Should we stick to the unit of study outline or read beyond it? And I feel like that's an obvious answer. It's really hard to read beyond many hundreds of pages, but what do you think?
Yeah, so you'll often hear people say, you know, you get out what you put in. And that's so true in law school. You know, there's a lot of material that you could read. You could spend 100 hours a week doing nothing but prep for law school, I'm sure. Obviously, you have to do the prescribed reading. You know, that's the baseline. That's what we're setting the assessment on. When I'm walking into a class, I'm assuming that people have done that basic required reading. Should you read beyond it? I think you absolutely should. And again, reflecting on my own experience, my marks in law school went up a lot when I started looking at multiple textbooks, when I was reading the cases in full for issues that you're interested in, looking at a few articles. You know, there's so many great electronic sources now that you can use that I didn't have in law school. So, you know, OSLI's LawCite, but just being one example, putting in a case name into a general search in OSLI so that you then get, you know, here's some articles that are on OSLI, here's some government reports, here's some cases. It's not saying you should spend, you know, 20 hours on every class, but doing a little bit of extra reading will confirm and consolidate your understanding, but might also help you to really identify, you know, what's the scope of this topic? Where are the edges of this topic? What are some of the more advanced arguments that I can bring? I've certainly had experience here with students who clearly are going off and looking at more recent cases being one example. I'm not suggesting you need to do that, but it can be good because, again, you're then getting judges to explain the important cases back to you by putting the cases through the citators and then seeing how judges are referring to it. And in some areas of law, that's really useful because the cases are really long, the facts are complicated. So, you know, you've got highly experienced QCs, you've got very experienced judges, and they're essentially saying, well, here's this case and here's what it was about, and this was really the issue, and here's what they found, and that's then been applied in these other areas. You know, that's just a great summary that will take you a long time to do yourself. So reading beyond it is really helpful. In my area of corporate and commercial law, I suggest students read the newspaper, you know, read the business section of the newspaper, read the business news online, because you'll then start to see the practical application of what it is that we're talking about. So I'm teaching insolvency at the moment. There's some great case studies that are being talked about every day in the media. And I just think if you can, you know, a lot of what we're doing in law school, and particularly the areas that I deal with, corporate commercial law, is very abstract. There's just lots of rules, there's lots of sections. If you can see real examples, I think it helps you to consolidate your learning. So reading more broadly is very helpful.
Yeah, definitely. And also on that point, as Jason said, reading the newspaper, but also asking your teachers where their area of study plays into in the world as it is. So like asking them where they can consult, where you should consult as well. Did anyone else have anything to say about that? And Nikki, not really.
I think that's all very like good advice. I just remember in second year, I sort of felt that I had to read beyond the cases, and the bad side of that for me was that I actually lost sight of what the prescribed readings were. So in the midterm assignment, I ended up just kind of neglecting actually what we'd learned in favor of all these extra things I'd read. And that itself wasn't very beneficial. I didn't do too well. So I think it's really great to read beyond, as long as you like keep in focus really what you're meant to be learning. And remember, that's the focus of often the mid-sem assignment. But, you know, I've made that mistake. So hopefully, you know, anyone in this Zoom right now doesn't fall into the same trap as I did.
Can I just add something really?
I would say I agree with that.
Yeah, can I just add something really quick to that? So when you're reading more broadly, be really mindful of the jurisdiction that these other readings that you're getting are based on. So an issue that I've picked up in my subject of corporate law is I'll see students referring to Canadian cases, to American cases, to New Zealand cases. And, you know, I know my syllabus. I know what the cases are. And if I see a case that I don't recognise, oh, hang on, oh, that's a New York case. Why on earth would they be citing that? Like, it's an automatic red flag. You don't get bonus points for citing cases that have no relevance to our jurisdiction. Even if they're saying the thing that you want to say in your assignment, it's irrelevant. Like, the approach that I take as a marker is, I'm a Supreme Court judge and you're seeking relief in my court. Don't cite American cases to me. Again, I'm not President Kirby. I'm not Justice Kirby. I don't care what happens in other jurisdictions. I'm applying as a first instance judge the law of New South Wales. So give me New South Wales cases.
Okay, we'll move on to the next question, which I'll address to Anuki. Is there a difference in preparing for a tutorial compared to a lecture?
I definitely think there is. In terms of preparing for tutorials, I like to focus on application and having enough understanding of the topics to be confident with a scaffold, or already being able to respond to the problem questions asked in tutorials if your tutor is doing that. Whereas by contrast, lectures for me are where I get my basic understanding of the content. And so there are definitely times where if I look at the readings and they just don't make any sense to me, I won't do them until the lecture. And then once I've heard the lecture, I'll then do the readings based on a better understanding of the content as a whole. And then I'll be better prepared for the tutorial. So I think tutorials are really focused on having a level of understanding where you can apply concepts and really understand how the cases relate to how a hypothetical might be decided, or a better understanding of the topic more generally. Whereas lectures are just a great opportunity to get your lecturer's perspective on the topic.
Yeah, definitely. Does anyone have anything else to say about that?
I might just add that, like, I know like your lecturer or tutor will stress this to you many, many times, but I really can't emphasize how important it is to just have a go at any problem question that isn't a tutorial before you come to it. I don't want to sound like a broken record, because I'm sure that you've already been told these things, but something that held me back was I felt like, oh, if I can't do it perfectly, then I shouldn't do it at all, and I should just go in and hear what they have to say. And that was not helpful at all. And I've now gained a lot more from tutorials, because I can see the mistakes I made and now I don't make them again. So really, really important, even if you only have 20 minutes to just scaffold it briefly. It's super important.
So what we want to see as academics is that you are engaging with the material and that you're having a go, that you've had to think about it. You've come up with an argument. There is no such thing as a perfect answer. So I think some students assume that we've got this kind of model answer for every question that, you know, we're looking at. And I know that there are some subjects where they prepare answer guides. They might be kind of rough model answers. I certainly never do that. I just have a list of points that I want to see discussed because I think they're relevant to that question. So law isn't about getting the right answer. It's about persuading the decision maker, which is not to say you're misleading them by, you know, telling them the wrong thing. You know, you can certainly have irrelevant points based on the question, but it's not like you're trying to get to this perfect answer. And, you know, the closer you get to that, the higher your mark. So I always tell students, you know, don't just go based on what I say. Disagree with me. Show me what your argument is. So, you know, we set a question. Here's the issue. It might be yes or it might be no, but the conclusion is irrelevant. If you think about that kind of common IRAC method, issue, rule, application, conclusion, just know that as a marker, I don't even look at the conclusion. And the reason is because it doesn't matter. It's a hypothetical problem. So you tell me they're right, you tell me they're wrong. I don't really care. If it's not clear to me, reading your answer, what your conclusion is going to be, then you've got a bad argument. So it's the application bit that is the important bit. It should be obvious. It's like, here's the issue, here's the answer, this is why it's the issue, applying and going through the law. So again, going back to the study group point, if you're in a study group, critique each other's answers, mark each other's answers. Because if you don't identify the holes in your reasoning or the weaknesses in your reasoning, the marker will. That's what we're doing. Well, you've mentioned this, but what about this point? What about that point? You've missed this section. So the more that you do that in preparation, the more, the better the argument that you'll have. And that's what we want, is a good argument.
Awesome. We'll move on to the next question, which is, well, actually, we talked about missing tutorials and catching up. Jasmine, you had pointed that out. Maybe someone can go into, maybe Anuki, what exactly are scaffolds? Are they necessary?
So scaffolds are a more refined set of notes that help you directly apply the principles you've learned in class to a problem question. And the distinction is that, for example, in a lecture, you're listening to the history of an area of law, you're writing down notes, and it's quite unstructured. Whereas a scaffold, you really take the principles in each case and set them out so you can see how they relate to each other and can see in a step-by-step way how you would go through a problem question. And this is really useful because it shows it, first of all, when you're studying, it allows you to see very clearly how an area of law would be applied, and it allows you to take the content you've learned and digest it for yourself and understand how it works in practice. And of course, it's perfect if you have an exam coming up, because instead of trying to come up with structure on the spot, you already have that structure built into your notes. And I think that kind of structure in your understanding of a subject makes a huge difference.
I have a comment on that. So, I mean, scaffolds are great. We use them as well when we're prepping for class, when we're looking at, problem questions we're going to discuss in class. They're really helpful. My one word of caution is, though, don't apply them in a slavish way. What I mean by that is, like, one of the subjects I teach is contracts. And I'm sure there's scaffolds out there that students are using which say, well, the first thing you do in a contracts exam question is you say, is there offer and acceptance, and is there consideration, and whatever. And what I've just been telling the students in my class this semester is, you don't always have to do that. Like, it kind of depends on the facts. It depends on what the issue is. If the issue is, there is an agreement, they're using the agreement now, and now there's a dispute, and, does one party have a right to do this? If I open up your answer and you say, well, is there an offer and acceptance? And here's half a page on what an offer is. I just look at it and go, you've got no idea what you're doing here. This is not an agreement issue. This is it. There clearly is a contract. You don't need to tell me there's a contract. The facts say that. So get to the bit that's relevant. So, and I've just seen it too many times that I think there's scaffolds out there that are telling people you always have to go through offer and acceptance. And it's just wrong. So don't be too slavish with it. Think about what really is the issue and then have issue-specific scaffolds. If this is what the issue is, this has already been established, so now I just have to go through the relevant bit.
I might just add as well, in addition to what's already been said, I've also started sort of making like a very high-level scaffold where it's just very brief, sort of easy to remember, but then also a more in-depth scaffold, just to avoid the problem that sometimes comes up with scaffolds where you can just oversimplify an issue, sort of identify it by a title and not actually engage in a discussion of the cases or the facts. So if you have time or it comes close to exams, I advise you to maybe start with a more detailed one and then also maybe have a super high level one in addition to that.
Yeah, definitely. I think what usually happens is throughout the semester, you'll be making notes based on each week's content. And when you get to that end of semester period and you start thinking about your actual final exam, that's when you're going to start condensing it and trying to make sure that in an exam, when you're looking at a problem question, you're ticking off every thing that you can think of and structuring and doing step-by-step processes. And usually those things get pointed out to you throughout lectures and with the content and tutorial questions. So yeah, definitely echo what everyone else has already said. This one is a little bit more of a bit more of a psychological one. Do you have any tips and strategies for combating? Oh, sorry. I mute when I talk so that I don't hear what they're hearing.
Can I just add a quick point to this too, though? Yeah. So in terms of the scaffold, you're just saying this in make sure you're going through all the details. And in an ideal exam, for example, you'd have enough time and enough space to do that. And really, really excellent responses do cover everything. But just know that, what we're looking for, what's the difference between passing and failing? It's addressing whatever the main point is. And so that's really the heart of your answer. That's what we're focusing on. And I see too often students, it's like they take the approach of every possible thing that could be relevant here, I'm going to write about. And the difficulty with that is that it's not like we have, here are the 3 issues, and unless the question says this, here are the 3 issues, so there's going to be 10 marks for this issue, and there's going to be 5 marks for this issue. It doesn't work that way. Most of us do kind of overall impression marking. So if you're only spending a paragraph on what basically is the main issue for this question, you're not going to do very well, just because you've raised a whole bunch of things that could be relevant. So just, again, scaffolds are great. They help you to focus your task. Don't use them too slavishly. Don't feel like, well, I'm going to fail unless I mention every possible issue here. I'd far more prefer to read an answer. Here's 2 pages, which is really solid on the main issue. And then when you've run out of time, I would have also talked about this and this. You're going to get a better mark by addressing what the core problem is.
Yeah, definitely. I think maybe a lot of students fall into the trap of thinking issue spotting is the way to get all the marks, and that the more you spot every single type of issue, you'll get more marks. So that's a misconception.
Yeah.
Yeah.
Issue spotting is a way to try and pass. If you're missing all the issues, you're going to fail, obviously. You can spot the issues, you might pass, but it's the quality of your argument.
Yeah. Do you guys have any tips and strategies for combating burnout and keeping a balanced lifestyle while studying? Maybe Jasmine?
Sure. I think one thing that I've already said, but just do what you can. So don't feel like you have to do everything to the most or the highest level possible. So for me, if I'm not able to go to the gym or go for a run or something like that, I might just do 20 minutes of yoga in my room or something like that. Or just doing little things like going for a small walk when I'm stressed, things like that. Because I think personally I had a mentality of, if I can't go to the gym and do an intense workout, then I'm just not going to do it and I'll stay focused here. Or, if I can't do all my readings right now, then I guess I just won't do them. And that just led to a lot of burnout because, your study and everything becomes the biggest thing in your life, but it is important just to carve out little bits of time for yourself throughout the day, even if it isn't huge, and just be really grateful and focused on that time that you have left to yourself. And another thing I've been trying to focus on more this year is having hobbies that don't involve looking at screens, just because with Zoom and COVID, I have been looking at screens a lot. So it hits 8 p.m. and my eyes are really tired. So whatever that is for you, whether it's yoga or reading or, pottery, whatever it is, try and avoid looking at screens, which I'm sure everyone is well aware of already.
I think I would also say try to build other pillars in your life to support you. If you do poorly in an exam or an assessment, which everyone, absolutely everyone has done, you want other areas of your life where you can feel like you have a greater perspective than having everything and your happiness be contingent on how you do in law. Another thing is I found having study groups again really helpful, because especially if you have the right people who will support you and will make you feel like it's not the end of the world. if something goes wrong. It's really much healthier than being in your room, especially if you're doing online uni, stuck in that room for hours a day, doing readings and going to classes. I think it's much healthier. And I think, of course, things like taking care of your health are super basic, but they do make a huge difference with stress.
So my comments on this, even though it's been a long time since I've been a full-time student, but I'd say firstly, echoing what Jasmine said, be kind to yourself. And I think it's easy, and I've heard that this happens, it's easy to think that law school is very competitive, that you're all competing against one another. And just as an academic, that really isn't the case. So we are doing criterion marking. If you meet the criteria, you should get the grade. It's not the case that I look at my results and go, well, I need 10% HDs and I need 10% fails and whatever. Now, in 20 years, I mostly get a normal distribution in the end of semester grades. Sometimes a bit skewed, but that's been my experience. So don't feel like if I'm getting a good mark, someone else isn't, or if someone else is getting a good mark that I'm not. Work together and support each other, because you'll end up getting more out of it in terms of grades and also just your general understanding. And then I'd also say, obviously there's people on this call who have a variety of career aspirations. For those, again, reflecting on my own area, for those who are interested in working in a large corporate law firm, marks are important. I'm not going to lie to you, they are important. But don't feel like there's this kind of standard that you absolutely positively have to meet. And, if you don't get Ds and HDs in every single subject, well, that's it. Your career's finished. You're wasting your time. You're wasting your money. It really isn't that way. Law firms, they're employing people. They're not employing machines that churn out HDs. And so all that a really great WAM will get you is an interview. It won't get you a job, and it certainly won't keep you a job. So law firms want people, it's a professional service business. This is a client business. If you can't relate to clients, it doesn't matter how brilliant you are, doesn't matter how many prizes you won, you're not going to be a great lawyer. So it's a client-based business. So, try and become a more well-rounded person. Read a lot. Meet a lot of people, have interests. If you go to your interview and they go, so what are your hobbies? I don't know. I've been sitting in my room for the last 5 years reading law textbooks. You're not going to get the job. So, and increasingly, even very large firms are putting in place systems to try and filter out some of the inherent bias in focusing so much on grades. They're looking for what other things people are doing. So, get involved in SULS. They're doing so many great things. Take part in competitions. It's a learning process. All of you are brilliant, otherwise you wouldn't be here. So don't assume that you're going to come in and it's just going to be just like high school and you're going to get HDs all the way. This is a learning process. This is not the same as high school. That's why it has, value in addition to your HSC. So don't be so hard on yourself. If you get a pass or you get a credit, it's not the end of the world. This is a learning process.
100%. I think what we'll do in the last 10-ish minutes, we'll open the floor to any questions from the attendees. Does anyone have any questions they want to unmute and ask us? Yeah, Hannah?
Hi there, guys. Thank you so much for hosting this in the first place. I was just wondering, so obviously you said law offers just a tremendous amount of extracurricular activities and stuff to supplement like the academic side, like you mentioned, competitions and things like that. If we wanted to hone some of the skills we're going to need as lawyers, like people skills and also skills in the courtroom, like what would be the best way to get involved? Like what are the best things you could mention, like to do with your extra time of all the things that Sydney has?
Yeah. As probably someone who's part of SULS, I should probably give you some options. The competitions portfolio is something that we run, and we have 2 people that head that at the moment, Felix and Caroline. But if you go onto our website, which I will just type here into the main chat, suls.org.au, there are a number of tabs on the top of the website, education, and then there's competitions. And competitions is a very busy portfolio. We have many different comps running throughout the semester, every semester 1 and semester 2. And some of the staple things that we do are mooting, which is like sort of like mock trials, like mock court hearing sort of thing, where you have 2 sides and you work with a pair. You work in a pair and you you have submissions and you practice oral skills, and then you have client interviewing skills, which kind of builds on that interpersonal skill that you might not learn in class. And then you've got negotiations, having 2 sides. I haven't tried it yet, but negotiations is also a good one. And also the other one is witness examination competition. So we've got a number of different initiatives that you can get involved in. If you've met someone, or even if you haven't, you would automatically be paired with someone through that pairing system. So that's something that SULS can do. Yeah, does that answer your question, Hannah?
No, it just, yeah, absolutely. It gives me somewhere to look. I appreciate it. Thank you.
No worries.
I might just mention really quickly though, like I love mooting and I've done a lot of mooting, but it is sort of almost like another aspect of uni. So make sure you're still doing things that are separate to mooting, sort of for like free time, like hobby sort of things, because like mooting is really great and it will help you understand uncertain areas of law and it will work on your argumentation skills, but it is still work, even though there's fun involved in all of that. So yeah, don't make that your only extracurricular or fun activity, I guess, is just what I'm saying.
Yeah,
absolutely.
definitely.
Thank you so much.
Thank you. I think another thing is that you can just do the preliminary rounds, and like I've done that. I haven't really gone through the other rounds, but just having that preliminary round with just doing it with someone as like a friend or someone I've met in class, and having a go at it and not taking it too seriously. We're like, I have to win the whole competition. You don't have to do that. You can just have a go at it. We have a question in the chat. How do you navigate statutes? CCP requires us to find certain sections that apply to the problem at hand, but how do we know which is the authority statute? A lot of statutes repeat information. For example, summary cases are heard in local court. This is sent to me privately, but maybe Jason, would you want to have a go at that?
Yeah, I mean, I'm always reluctant to talk about other subjects, and I don't know if this is an assignment or something that you've got. So, you know, I'm not telling you what you have to do for assessment tasks. As a general question, like navigating a statute, the statute that I deal with in corporate law is actually it's 3,000 pages long. So I feel like I'm reasonably confident at navigating through statutes. This is where the secondary sources are really helpful. You know, so go back to your textbook, use the tables and the indexes in your textbook, because they will then almost always have a table of statutes. Look at, the relevant sections, use the index at the back of the book, because that will then have subject headings. And you say, well, okay, I don't know what the section is here, but maybe I know keywords, maybe I know some of the subject words, have a look at the index. I tend to view all my statutory materials and cases online, and do Control F searches. So make sure you can view the statute in its entirety. So one of the problems, if you're using OSLI as an example, is that it has separate web pages for every single section, whereas you want to view the entire thing. So actually download the whole thing, maybe as a PDF, or download it in HTML format. So you've just got one big web page, which is the whole statute, and try doing Control F searches of the different keywords. Go back to the slides, because the lecturers are probably using the correct terms that appear in the statute. So that's one way to go through. And then if you think you're onto the right section, well, it seems like this is relevant, but I'm not really sure. Is there something else? Then use those sections in the citators. So if you're on OSLI, for example, so go to the section, and on the right-hand side of OSLI, depending on whether the new one or the old one, it's a massive database that link back to that particular that would be how I would approach that.
If you do have like the statute and then the regulation made under the statute, I think it's okay just to sort of point out both of them, or if like, a provision in the statute led to the regulation, like you can just put both of them in as well. But that's all I'd add.
Any other questions from the floor, attendees?
Can I just share a general tip if there's no other questions? So I've been chatting to a few students over the last year or so, just kind of about career development type stuff and thinking about, applying for jobs. I'm in corporate law, which is kind of 4th year for LLB students and late 2nd year for JD students. So they're often looking at clerkships and grad positions and those sorts of things. And one thing I'd just say to everyone in general is think of yourself as a brand. It's easy for me to say that as a corporate law professor, but think about the sort of footprint that you're putting out there on the web and in social media, and think about the message that you're trying to sell that you want to work with. So maybe you want to go and balance something like that. That's fine. You want to be a mergers and acquisitions lawyer, great. So think about how can I build my online brand so that it's consistent with the message that I'm selling to the firm when I'm applying for a job. Because what I'm seeing is some students who say, oh yeah, I want to be a corporate lawyer. And then, I just go on their LinkedIn and they, the profile pic in the LinkedIn, they look like they're having a drink at the bar or something. It's like, the message is inconsistent here. So it's one thing if you want to have, private chats with your friends, and I'm not that big on social media, there's things that disappear automatically and all that sort of stuff. That's great, go nuts. But the permanent stuff that's out there on Facebook and on LinkedIn and these sorts of things, that's your professional brand. And, this is relevant not just if you want to go and work at a big law firm, but if you want to go and work at a company, we check that stuff. When I'm looking for interns, I'm going on their social media and I go, oh, no, this is not the sort of person I want to work with. So think about that stuff. The process to get a job out of your law degree starts now. It's never too early to start working on that. Building your CV, getting different opportunities to show that you are a well-rounded person, that you're someone who can work with a lot of different people, that you're someone who's going to be of value. You can work with clients. That's, like I said, it's a professional services business. Write things, write little posts on LinkedIn as an example. I'm not saying you need to write law journal articles, but have a message about who you are and who you want to be. And that's the sort of value proposition that you're selling to your prospective employer.
Awesome. I think the last thing I'll say, just in terms of getting experience, SULS, Sydney University Law Society, has applications open for our committees. So if you wanted to be part of the competitions committee or the careers committee, and we do go to Sydney University, we do have a big name, and being part of our law society is going to kind of get you those points, but also get you involved and get you to dip your toes into different kinds of experiences and make new friends as well. So I wanted to jump off that point in terms of resumes. This is something you would put on your resume as well. So yeah, if there are any other questions, we could finish up a little earlier. Yeah. Okay. I think we'll finish up, guys. Thank you so much to our speakers. Thank you to Jason. It was such honestly, I think if the law school has a TED talk, you need to be on it. You need to be like an inspirational talker. And Jasmine and Anuki, thank you so much for having that student experience voiced to us as well, which is also very important. And thank you to the sponsor and to our attendees.
Thanks a lot. Good luck, everyone.
Thanks, everyone.
Thank you.
Bye-bye.
Cute. My God, he's so good.